That work for Alan?
Can y'all hear me? All right, so no, thank you very much. And I feel halfway okay. I'm going to be kind of coughing and sniffing in y'all's ears. But as Shanoa said, I'm an attorney here in Austin. Been practicing law for, 24 years. Do real estate and construction law, and got into the creative financing stuff a long time ago, 03 or so. And then when the recession hit, it became very, very important to my clients, and I really boned up on some of the law. I like to say I've been unscrewing people for 24 years because my clients always call me and they say, "Alan, I'm screwed. I did something wrong," and so I just get them unscrewed. So that's what I do. Here's a fancy disclaimer, but I've consolidated it into. I'm not your lawyer, so you can't think that I am while we're talking right now. This stuff could be wrong. More accurately, it may have changed. Always hire an attorney, and don't steal my stuff. So that's my disclaimer. We're gonna talk about lease purchase options, and I like kind of having a conversation as opposed to some type of professor speaking thing. If you have questions, interrupt me. And we can talk as we go. If it's something I'm going to handle later in the presentation, I'll push off. But let's have a conversation. Who's heard of lease purchase options and maybe something that might be difficult in regard to lease purchase options? Anyone?
What's the law that says you can do it?
Well, so you can. So at first we were saying law says you can't do them, and it's weird you can. It's just you can't do them right. So now I've just skipped 20 slides right there. So we're going to go to the 21st slide. So here's the reason. In 05, there was a problem. Sellers were selling properties, lease purchase options, and then minor defaults would occur, and they would go and steal that property back from these prospective buyers. So something needed to occur. They were taking advantage of these buyers, and then the law came in, and Congress came in and passed a statute, this statute, and if they were trying to overprotect, they did very, very good. If they were trying to make something that was internally conflicting, they did good. If they wanted to make one of the most toothy statutes out there, they did real well with that too. There's the legal definition. That's from the statute 5062A. But here's the bottom line. If you're signing a lease agreement concurrently with a purchase option, then that's going to be governed by the statute if it meets the criteria. And it'll be regulated. It does include a contract for deed. And I know lots of y'all are familiar with that. So just understand that a contract for deed is a lease purchase option contract. Applicability. It applies to all properties that are going to be used as a person's residence, and there's a presumption that a lot of 1 acre or less is a residential property to be used as a residence. It's a rebuttable presumption, and the reason that's important is because it doesn't apply to commercial transactions. So if you're selling a property over to an entity or someone who's not going to be the end user of that property, living in that property, you're free. What is it the military says? Weapons free. Go ahead. It's not going to be governed by the statute, so you don't have to comply with anything that we're talking about tonight. It also doesn't apply to, there's a long definition under 5062C, but the bottom line is 179 days or less, and you don't have to comply with that statute at all. So that's important. Where this comes into play is you've got a transaction that's trying to close. There's some type of impediment, and Phil Grove has used this with my office. And you don't want to convey the property and do a lease back because there's problems with foreclosure trying to recover that property. So you can do a short-term lease purchase option, and that's a far more protective vehicle for the seller to go that route. So if it's 179 days or less, you're good. That's not 6 months. You end up on some 31 days, you're going to be over 180, and you need to comply with the statute. And a month-to-month or renewing agreement won't work. People have asked me. A verbal agreement won't work. People have asked me. And your revolutionary idea won't work. there's a fellow down in San Antonio, and he's aggressively advertising that he's got a lease purchase option solution, and he's doing dozens, if not hundreds, of these things per month. And I called him, spoke with him, and he's good. We went down the statute all the way and got down to the last one. He said, well, that one we don't do, it just doesn't matter. And so what we're going to talk about in terms of the penalties, every single one that he does is subject to those penalties. Some of the pitfalls are simple. You got to provide a survey that's no older than a year. You got to get copies of liens and all the HOA docs and stuff. There's a cancellation period that's more than the usual. Excessive late fees are banned. Doesn't tell you what excessive late fees are, just says excessive late fees are banned. You have an annual accounting statement that you have to provide. You don't provide that, you're in violation of the statute. There's a 30-day unconditional right to cure as opposed to a 20-day under the Texas foreclosure laws. And my favorite, second favorite, if the buyer tenant feels that you as seller landlord are in violation of the statute and they're owed money as a result of that violation, they can just deduct it from their pay and send it over to you. It's not a judicial action they have to take. They just unilaterally go ahead and do that, which is fun. And any violation is a DTPA violation. Thank you very much. Giving. DTPA, if y'all don't know, provides for 3 times damages. And so that's a pretty toothy statute in and of itself, but not as strong as this fellow. More problems. If you have an agreement, let's say you're in a 5-year lease purchase option agreement, the buyer tenant can come over and say, well, here's the terms of what our purchase would be. I'm going to give you a promissory note, and then you deed the property to me. So you no longer have a lease purchase option agreement anymore. They're the owner of the property. Have no idea why the legislature did that. It completely flies against everything that would be a lease purchase option agreement. The seller at that point in time, once they receive that promissory note, would have to convey the property over to that tenant buyer. And that's not the actual problem. So here's the technical issue. You can't enter into a lease purchase option agreement with a purchaser if you don't own the property free and clear. And there's an exception. You just get permission from the lender for the conveyance of their collateral. So you go knock on Bank of America's door and say, hey, I'm going to sell your collateral, this property. Can you give me something in writing that says that's okay? And if you get that, please call me. I'm going to hire you immediately. You're not going to get permission from the lender. So that's where this other fella messed up. He said, well, we just don't get the permission. And I said, okay, go with God. It says the subsection doesn't apply to a property that's encumbered by a loan or a lien that doesn't have a due on sale clause. And we'll talk about the due on sale clause, but I assume some folks have heard of the due on sale clause. If you find a loan that's been put in place within the last 30 years or so that doesn't have a due on sale clause, give me a holler. I've seen one. I think it was from about 81 or 82. So that was a little bit later. I was surprised, but they all have due on sale clause, so that exception is a not. And here's the clincher. If you violate the statute, the purchaser is going to have a right to cancel that lease purchase option agreement, sue under breach, and have the right to receive all payments of any kind, a rescission of the contract. So you put the parties back into a position they were in before they met. They're going to receive all the payments they made to the seller. So you have yourself, and this is why that fellow out of San Antonio is I think, just playing with fire. If some unscrupulous attorney wanted to go and get his client list and knock on their door and say, hey, do you want to receive all of your payments back that you've made in regard to this purchase? And I'll keep 20%, you take 80%. They're going to say, yeah, I'd like to live free for 3, 4, 5 years. And also get reimbursement for all the taxes that you've paid and any improvements that you made to the property. So that's the problem. if you mess up in any form or fashion under the statute, then the buyer is going to be able to really hurt you. So if you can comply, it's some builders do it. You own the property free and clear, sort of. You have a company over here that's actually the lender. It's a hard money lender, let's say. They actually do give permission for this lease purchase option to occur. Then good, you've got around that big obstacle, but you still have an issue in regard to all of these little things that you have to do, annual accounting statements. You miss one little thing and you're going to be subject to giving all the dollars back. So lease purchase options are allowed, but not viable. It's just not an option that we can do unless it's commercial property or less than 180 days. So the second part of what we're going to talk about tonight is a solution. And the solution to this is a mortgage wrap. It provides for essentially the same thing as a lease purchase option, but isn't governed nearly as vehemently under the statutes. We're going to kind of go slow. I know we have some guys who are new and have some guys who are experienced, but we'll kind of be on a little bit of a roller coaster tonight. We're going to have some basic information, and then we're going to have some higher level information. So if you get behind and you want to ask me a question, just raise your hand and we'll talk about it, because I know for an absolute fact that I'm going to leave a substantial percentage of the folks behind unless you're raising hands asking questions. Definition, seller financing, and it is seller financing when you're doing a mortgage wrap. That doesn't pay off the current mortgage lien on the property. So Bank of America is going to stay as a lender. So the property, so let's I guess stop the presentation and kind of just talk. I own my house. I've got a mortgage. Bank of America is my lender. I owe $200,000. I'm going to go and sell my property, seller finance. Buyer comes up, they're going to pay $300,000 for my property. We sign a promissory note. We have a deed of trust, and I sell that property over to them for the $300,000, and they have to pay me each month because I'm a lender. But Bank of America is still the lender to me. I don't own the property, but I have a loan in relation to that property. I still have to pay my Bank of America loan each month also. That's a mortgage wrap. You leave the existing loan in place and seller finance your property. All right, so let's call time out. Someone asked me a question. Who makes the payments? Let's answer that, because I think that's good. Due on sale will come in just a second. So the best way for it to occur is use a third-party loan servicing company. The buyer pays the full amount of the dollars over to this third-party loan servicing company. You know, same as Green Tree and heck, Wells Fargo is a servicer. That third-party loan servicing company receives the, let's say, $2,500 payment. Wells Fargo's or Bank of America is supposed to get $1,800 of that. Now I got to do math. And so $700 is coming over to me. That third-party loan servicing company shoots those checks out. The reason that's good is because if you have the buyer saying, well, I'll just pay Bank of America directly, seller doesn't know if it occurs or not. If you have the seller saying, give me all the money and I'll pay Bank of America, buyer doesn't know if it's occurring or not. Third-party loan servicing company is going to send out notices when there's a default immediately. And so that protects both buyer and seller. Now, big asterisk behind that is, if I'm buying a property as an investor via a mortgage wrap, I'm not using a third-party loan servicing company because I know I'm going to pay. So I'm taking over the responsibility of that mortgage, and I'm going to pay. Now, if the seller says, well, no, I need some protection, you have to acquiesce and get a loan servicing company. But you know, Phil and Shanoa aren't getting a loan servicing company for all the properties they're picking up. They know they're going to pay. And as I said, due on sale coming in a second. So let's keep discussing it in general. It is seller financing, and so I break seller financing down into two types of transactions. One is where there's no underlying lien. That's simple. You got a promissory note, deed of trust. You don't have these disclosures. You don't have all these problems. You're just seller financing your property. The other type is an underlying loan exists, and this includes, if we're talking about mortgage wrap, subject to assumptions, and I'm going to talk about the definition, or at least my definition of these These are also used in what's called assignments. You can have a contract that you're assigning and still use these methodologies. Let's talk about some terms real quick, really for this presentation, and then if you're working with me at all. I call a subject to. Whenever I say subject to, what I'm talking about is someone who's, let's go back to my scenario. I owe $200,000 on my mortgage. My property's worth about $210,000, $215,000. Not enough fat in there for me to go hire a real estate agent and sell this property and make any money. I'll have to come to the table. So some investor says, well, that's fine, I'll come and buy that from you. What they're going to do is take over my $200,000 mortgage, pay me a couple $1,000s, and I'm out. I'm not expecting anything else from this. Did I do it right? So I like make me the action person. I'm taking over that mortgage, $200,000 payoff left on that mortgage. Property's worth about $215,000, and that seller is gone. They're expecting no more from this. They just know that they have a loan on their credit reporting. They're not an owner of this property, and they're never expecting any more monies. You're just jumping on and taking over that mortgage wrap. So when you think about mortgage wraps, it's a promissory note coming and wrapping around an existing note. This one wraps real tight. It's the exact same amount of the promissory note. So that's what I mean by subject to. You're just taking a property subject to the existing loan, and it's yours. Yes, sir?
Are you notifying the lender, the primary lender, what you're doing?
No, we've over the years toyed around with some different stuff. There's some legal terms, estoppel and things of that nature, which you may have heard of. So some folks will put a little note into a payment and ship that note off to the lender, knowing that the $7 an hour person that opens that payment is going to look at that and go, this doesn't fit into a bubble or a box. I'm not going to do anything with it. And they argue that that's notice. Similarly, I can argue that the recording of the warranty deed down at the property records is notice to everyone. It becomes a non-issue in a second when we talk about the due on sale clause. So the answer is no, and I don't think you should. Other attorneys may have a different opinion. Yes.
Who keeps paying the taxes on the
Buyer. The buyer is the owner of the house. The buyer has all the responsibilities, obligations, and benefits of home ownership. So they're also receiving that tax benefit, the interest write-off. The seller shouldn't be taking the interest write-off because they're not the ultimate responsible party. I say that because I bet some maybe do. Yes?
What's the insurance if you're not using the third-party loan servicing company? The guy, what is the buyer's actually going to pay your loan that's on your name on? And what's the insurance or the recourse to that?
You're saying not use a third-party loan servicing company?
Yeah, if you're not, what you're talking about now.
Well,
The seller know you're going to make the payment.
they don't. They don't. But if you're, I mean,
What's written up that the recourse for that?
well, no. If you don't pay, so if I sell my house, seller finance via mortgage wrap, I'm a lender. I'm Bank of America. I'm Wells Fargo. I foreclose. I have all the redemption rights of any other conventional lender. You send the 20 day. Yeah. No, that's it. I thought you were saying some kind of assurance that you are going to pay
Well, yeah.
outside, but no, you have redemption rights. You foreclose. Yes.
This might be a CPA question instead, but when Wells Fargo sends the 1099, whatever it is, about the interest at the end of the year, but that has Joe Seller's name on it, and Sally Byers been paying the interest, how is there a way, what do you do with that?
So-
The buyer gets the write-off.
So the seller can't use that because they're not actually making those interest payments, or maybe they're making them and being reimbursed, however you want to look at it. But I would say a tax person is going to tell them they can't claim that, and the third-party loan servicing company will have another 1099 miscellaneous out to the buyer, and they use that. If you're not using a loan, what's that?
Equal dollar amount to it.
Yes, yeah. If you're not using a third-party loan servicing company, you can get your tax guy to just fill in the information.
Okay.
All right, so that's subject to. Assumption, you've really got qualified assumption and non-qualified assumption, but whenever someone says assumption, you're usually saying that the lender is giving permission for the sale of that house. That's not going to occur. Bank of America is not going to say, sure, go ahead and sell my collateral. I have had small banks actually allow this in non-commercial transactions. I was a little bit surprised. In commercial transactions, it happens all the time. They just qualify the new buyer to an extent and either keep the old borrower on the note or they may take the old borrower off, I've seen. But residential, conventional lending, Bank of America is not saying okay. And then I use the term mortgage wrap whenever I have what I call an end buyer user buying from an owner seller. It's just a conventional seller finance transaction where, like I said, I owe $200,000, I'm selling it for $300,000. Well, I'm still $100,000 involved in this thing. I want my $100,000. So when this loan gets paid off in some form or fashion, only $200 is going over to the Bank of America. I want my $100. So I'm integrally involved. What is it they say? I have the interest of the pig in the breakfast, not the chicken. So that's what I say for mortgage wraps. I also use the term mortgage wrap to talk about them all, subject to assumption or mortgage wrap. So that's my terminology. Yes.
So what is your collateral for when you do the mortgage wrap for the $100,000 that you do?
What's the what?
What's your collateral? How you insure?
The property. So
Isn't it collateral for the bank?
So I'm in a second position. I'm in a second position, exactly. So yeah, bank is going to have the first 200. I get the next 100,000. If the property doesn't sell for 300, then I lose first.
I've got a question.
Yes.
I bought a bunch of these and put them into LLC. What do you think of that?
I think it's fantastic to have any real estate property that you own in an LLC. It provides for a layer of liability protection. I wouldn't put all of my properties in the same LLC. If I had a substantial amount of equity in one of the properties, I want to protect that equity from the ones that don't have as much. So we have a problem with one of the properties. I get sued. They get a judgment for $250,000. If that one property is the only property in the LLC, then that's all they can pursue. If I have other properties over there in that LLC, they can start going after those other ones. And the best way to accomplish that is a series LLC. So you have a what I call a parent company and then a sub LLC, and you can create those series. It's probably more expensive to get it set up in the beginning, but to create another sub LLC, an offshoot of it, you just draft up a 1 or 2 page document, and you have a new entity right there. It's kind of a new thing in the law, and series LLC is the way to go. Absolutely. Yes.
Quick question, with that, then you have to file the same filing fee for every sub LLC?
No filing fees. There's actually no recording whatsoever, which is dumbfounding to me. With as much as the government wants to stick their nose in our business, I'm surprised the legislature has allowed this to go. I suspect it's going to go away. But no recording, no fees, no nothing. Yes.
What do you think about the trade-off instead of the multiple LLCs or LLC for property to just get the $4 million umbrella policy covered? If you only have 2 or 3 properties, it's 50. What do you think about the trade-off using the umbrella policy, but actually as opposed to the LLC?
I think once you have too many, then you're exactly right. An umbrella is going to be easier. Yeah.
And any feeling for what that crossover point might be?
You know, if it was me, what I would do is put my lower equity properties together and actually have more in there than I would if I have. I mean, if I have enough equity in one property, it may be its own little series LLC, and there's headaches with that. I mean, you have to have a bank account, a separate bank account for that. You have to have separate accounting go on. So it's a headache. But if I've got $150,000 equity in a property, I don't want to subject it to any other problems. So it would. I can't tell you the number. It would depend on the amount of equity that we're dealing with.
Okay, another follow-up question. I've been educated in another methodology where you have a parent banking LLC that holds the note of all your properties. And so the equity in each lower level series LLCC for each property may only be worth $10,000 or $15,000 of equity, and that significantly limits your liability in that particular piece of property because they can only go after the equity.
Right, and I have seen that occurring too. It's going to get outside of our discussion here. And I'm not a tax attorney. I would think that there's some substantial tax benefit to doing it that way also. But that's outside this and outside me.
But your liability would be even significantly
Decrease, yeah.
Because it's only based on the equity in the property.
Yeah, you have an entity that is housing a great portion of the potential risk with $0. So it works. Yes.
Earlier, they were talking about using your self-directed IRA to do one of these. Do you still then need an LLC for that, or how does that all go together?
It doesn't change it.
You still need an LLC.
Yeah, well, you don't need it.
I mean, if you buy it with that money, you still need it.
That's just the IRA doesn't hold it. You still hold it in your entity, right? I'm asking questions to. Yeah, so it doesn't change ownership. That's just source of money. Yes.
If they can't speak the IRA.
Oh, no. IRA's locked. Ask O.J. Simpson. He's correct. Yeah, it's not gonna. That situation isn't gonna bleed over. It's just a source of money. Yes.
Hi. Question about the series LLC. So another attorney's opinion was not recommend them because they haven't been tried in the court.
I don't think there's any problem in terms of them being tried in the Texas courts. Some people have asked if they can use a series LLC to get around the Dodd-Frank issues by putting only 3 properties in each series. And my answer to that is, don't know. Don't want to be the first to get asked by the judge if that works or not. Because the answer, in my opinion, the answer is going to be no. But I don't see any problem. And I associate with a tax attorney that has an LLM in tax, and he's also a CPA. He creates entities left and right. I don't even do it anymore because his machine is much better than mine. Plus, he has the tax advantage, the tax knowledge. He uses the series LLCs. He's fine. So I don't know. But they say what lawyering is kind of like mothering. You get 3 mothers in a room. You got 3 different ways to raise a child. So same thing with lawyers. But I'd be fine talking with the attorney. I like learning. Yes.
I have an opinion about the do-on sales clause. I'll probably share with a lot of investors here. But when it comes to doing the subject deal and getting a house and getting homeowner's insurance on that house, I'm curious what you would say about that, and how you would have your insurance person have it structured.
So let's hold because it's coming up. Both of those. All right. So we're going to kind of go quickly through some very broad and powerfully encompassing statutes, but we don't have time to go over all of the issues there. There's a SAFE Act. That's the federal SAFE Act. There's a T-SAFE Act. That's the Texas SAFE Act, and the Dodd-Frank Act. These 3 acts, they try to govern seller financing or lending, and want you to be a licensed residential mortgage loan originator if you're going to be actively doing these things. One-offs, they're not trying to govern, so they came, and if you're not licensed, you have to use an RMLO. So either be an RMLO or use an RMLO. However, they have de minimis exceptions. So SAFE Act came out and said no de minimis exceptions, and federal government said, hey, can y'all comply with this or we're not going to give you money for roads and stuff like that. So the states complied, but then the states asked, hey, we want a de minimis exception, which says under the SAFE Act and T-SAFE Act, no more than 5 in a rolling 12-month period. So if you're doing 1, 2, or 3 or so, you don't have to comply with this. You don't have to be a licensed loan officer. Don't have to use a licensed loan officer. The Dodd-Frank Act is a very complex act. It's, I think, 2,000 pages of written law and references 11,000 pages of other law. There's a couple thousand pages still to be written. It's bad. I'm trying to understand it, and it's difficult. But at any rate, in terms of the seller financing items, 3 properties or less in a rolling 12-month period, and you don't have to comply with Dodd-Frank, sorta. There's really only one true exception to Dodd-Frank, and that's a one-time sale. If you're an end user to an end buyer, you can do it, and you don't have to comply with any of these statutes. But once you get above 1 with Dodd-Frank, you still have to. I like this. There's an exemption to the de minimis exception of the Dodd-Frank Act, and so if you have 2 or 3 or more, you're going to have to comply with these items. Seller didn't construct the home; they're not the builder. The loan's fully amortizing. There's not a balloon allowed. And there are ways to do a balloon, but we're not going to be able to get into all of that, and we're going to not mess with that as investors, and we'll talk about that. The seller determines in good faith and documents that the buyer has the ability to repay, ATR. The ability to repay is about 8 different criteria, vague and nebulous criteria, that the legislature has said will prove that a buyer has the ability to repay. In my opinion, if you have the ability to repay, you can get a conventional mortgage. So I don't think under strict scrutiny, anyone's going to be able to say, yeah, this buyer had the ability to repay. Sure, Wells Fargo and Bank of America said no, but we kind of confirmed that they actually could pay. Yes?
So there's no balloon at 61 months allowed?
There is, if you meet certain criteria. It's going to be difficult to meet those criteria. You're going to have to be an accredited lender under the one that allows for that balloon. And then loan has fixed rate, adjustable after 5 years only. We at first started trying to get around some of these things by just making the loan escalate very quickly in interest, and that would incentivize the buyer to get out of that loan, but we can't do that anymore. These all also only apply to residential properties. If it's a commercial property, and by commercial what I mean is it could be a residential property, but someone's buying it for investment use. So investor selling to investor, you're fine. Ignore all these. It's just when you have the end buyer being a user of that property and its residence, then you're going to need to get around these things. We can talk more about Dodd-Frank and things of that nature, but again, it's a very, very complex topic. I got about an hour and a half speech that we can do on that later. So the due on sale clause, I say it's a non-issue. It's the most talked about topic of a mortgage wrap and the most infrequently occurring issue in real life transactions. I used to ask if anyone has first person knowledge of a lender that is called a performing note, someone who's paying their note due based upon just the due on sale clause. And usually someone raises their hand and says, yeah, my cousin's sister, she knew an investor one time up in Michigan that happened. I'm like, well, I'm talking about first person knowledge. And so no one would raise their hand. I can't do that tonight because it finally occurred and someone would raise their hand and they would be accurate. It did occur. Now, it was a home equity loan, and I think the buyer or seller walked into the lender and said, hey, I either sold or bought this property. Here's all my documents. You need to start dealing with me now. The lender didn't like that too much and said, we want to call it due. It was neat because the attorney they hired to help was a friend of mine. And so I have all these theoretical ways to handle when this occurs, but I've never got to test it at all. So I was secretly happy this was occurring for my clients. And then I was very happy whenever it was a friend of mine that was going to represent the bank. So the fix that we did and the fix that I think is good is we just deed the property back over to the seller, have a purchase agreement from the buyer, from the seller again, sign a deed back over to the buyer at the same time, so I had them both in my office, both the deed curing this problem, giving the property back to the buyer, and the deed giving it back, or the seller, and then giving it back over to the buyer, and recorded the deed and shipped it over to an attorney friend and said, all right, we're fine. What now? And they stood down because we cured the defect. It's a permissive statute or permissive clause and says, if you sell my property, I may come over and tell you you're in default. Same as if you don't pay the mortgage. Same if you don't keep insurance on there. Same as if you lease it for too long. So it's just a typical, normal, everyday default that you can cure. You've got 20 days to cure it whenever they send you a notice. So we just cured it. And I sent it over and I said, na boo boo. And so I didn't hear from him at all. So then what we did, we waited a little bit of time, and then I recorded the deed back over to the buyer. Nothing changed for buyer and seller whatsoever. No money change, no money difference. My office paid for the very, very extensive cost to do this, which is about $80 for the recording fees. And we sat there. And so I was thinking, you know what, I think they're probably going to check. And secretly, I wanted them to check. Because I couldn't have a better situation than my friend over there, because what I wanted to do was, hey, y'all are in default again. All right, well, good. Notice me of that default. And then we'll just go cure it again. And so I wanted to ask him, I say, do you feel that the bank is impotent to do anything whatsoever to stop us from doing this cat and mouse game? And unfortunately, fortunately, we didn't get to check. I say fortunately because the client's here, but if they weren't here, unfortunately, I didn't get to check. So the due on sale clause in my book is an absolute 100% non-issue. So I consider the due on sale issue to be a non-issue. If y'all got a different opinion, I will speak with you on it.
Doesn't it only work if the buyer, somebody doesn't say, oh, you're going to give me back your deed and screw you or something?
So the seller, the original seller says, pound sand, it's not my problem, let them foreclose. You do need them, and I include in investor transactions language in the deed of trust that says they're required to. So in theory, if they didn't, then that would be a lawsuit against them for all damages that they incur, which would be the loss of the property, all their equity. So it's they're subject to some liability there. If your seller is gone in Madagascar and you can't get them, you're gonna have a problem. And no, you can't sign the deeds in advance and use those. That wouldn't be a fix. But yeah, you got an MIA seller, there's a problem. But happened once in a decade and a half for me. I'm just waiting for the next one, hoping. All right, any questions? Say again? The heirs really step in at that point in time, so you're asking the heirs to do it.
Okay, so you still don't give an extension to the 20-day period? Contact the heirs in that 20-day period?
Seller doesn't have to comply with anything of that nature, no. They don't have to give you more time. Now, I think, you know what, I did ask for more time from this lawyer on ours. I forget, I think we did have an out-of-country signer, and so it took us longer. I asked for more time, and most attorneys will give you that. Most. All right, so let's talk about how to do a mortgage wrap. We're gonna kind of go a little bit broad here. If y'all want to drill down, certainly let me know. We're going to use a TREC 1-to-4 contract for a mortgage wrap. There are some contracts out there that are little 2-page contracts for mortgage wraps. There's some contracts out there that are 30-page, little proprietary contracts. I don't like either one of them. The TREC 1-to-4 contract is generated by attorneys who are working for state agencies who are changing that contract to comply with law changes, to comply with common law, to court cases that are being passed. Let's let them do the work and use their TREC 1-to-4 contract. It's strong. You're going to choose either paragraph B on the bottom of the first page, 4B, if it's an assumption, 4C if it's a seller financing. The loan assumption addendum that you're going to fill out in conjunction with this is form 41-2. Then for the seller finance addendum, that's 26-6. On the seller finance, paragraph F? No, it's the assumption addendum. Assumption addendum, paragraph F or E or something of that nature says we're going to get permission from the lender for this assumption. Cross that off and initial it. We're not getting permission from the lender. I do have a wraparound addendum that some investors will use. It's about 5 or 6 pages that no one will sign. It's designed to cherry pick some information out of there that you may want and generate your own addendum. But it is overly inclusive. Then, after you get the contract in place, just like any normal transaction, you're going to go receipt that contract with an attorney title office. I emphasize attorney title office, and we'll talk a little bit about that. I own Texas Title Ceshker Group. I'm an attorney. I own a title office. We function exactly like a title office. There's hundreds and hundreds of attorneys in Austin that own a title office effort, and some of them are practicing attorneys, some of them are absent attorneys, but you're going to receive the contract with an attorney title office, and we'll talk about why in a second. You're going to purchase title insurance on this transaction. If anything goes sideways, you want the title insurance company paying for your lawyer, not you. I had a situation where survey coverage, it's paragraph 6 of the TREC contract, 6A, 8II, something like that, talks about survey coverage. Get survey coverage, and this is off topic actually, but just a tidbit for y'all. It's 1% of 5% of the sales price. So $200,000 contract, you look at, what's that?
5% of the title cost.
Which is about 1% of the purchase price. Right, so I did it backwards. 5% of 1%, so $200,000 property, $120. I had a client, didn't get the survey coverage. House ended up being at the front of the lot, not in the middle of the lot, and he spent $40,000 in attorney's fees, and we won, but he didn't get his attorney's fees back. Get the survey coverage. It's very, very cheap and fun. After that, everything runs like a normal transaction, sort of. Come on, I'm a lawyer. All right, so we're finally to the question that was back there. Major concern is homeowners insurance. This has bounced back and forth in several different ways. For a while, we were saying, all right, well, buyer and seller, both of y'all get insurance. That'll belt and suspenders this thing. Then we're saying, seller, you can keep insurance only, get some renter's insurance. Then we're saying, buyer, so here's the way it's working for us right now, and it's working very, very well. The buyer is going to purchase new insurance. The seller, I say, need not maintain insurance, can't maintain insurance. I can't go get insurance on the Golden Gate Bridge. I can't get insurance on this building. I'm not a vested owner. So in my opinion, it's insurance fraud if you have insurance on a property that you don't have a vested ownership interest. So the seller can't maintain insurance. I should update this. The seller is going to be listed as an additional interest. At this point in time in our little conversation that we're having, I'm parroting words from an insurance agent. So if I can't tell you exactly what some of the exacts are on this. There's a declaration page that's filled out. I don't know how to fill that deck page out. The insurance guys do. But the seller is an additional interest, not an additional insured. The lender is going to be in the mortgagee clause just like normal, every normal transaction. And that allows them to check off, okay, well, we're covered. The seller being listed as an additional interest allows them to check off, all right, there's our seller's name, and that complies. If you fail this, the lender is going to put forced place insurance on the property. Forced place insurance is anywhere between 1.5 to 3 times the normal cost of insurance. Bottom line is it's more than what the insurance was, so the buyer is no longer going to be paying the full amount needed because the insurance escrow is going to be higher. Then the payment's going to be short of what's needed. Lender's going to say you're in default. Buyer's going to say I'm paying what I'm supposed to. Seller's going to say I don't know what's going on. And then they're going to come and start foreclosing on the property. So this is the least often discussed, most often seen problem, is not getting the insurance in place. The insurance agent has to be familiar with mortgage wrap insurance. Aunt Lily is not going to do your insurance on this transaction. She can have your house and your motorcycle and your car and your boat, but she's not doing it on this transaction. You can ask if she can do it, and then she can call me, and then she can ask me how to do it, and I'm going to tell her I don't know, because I don't. I cannot advise her how to do it. You have to get someone who knows what they're doing. And I say that failure to get insurance in place, most common reason for a mortgage wrap to fail. So, as a gratuitous plug, Mike back here with Texas Independent Insurance, raising his hand, knows how to do insurance on mortgage wrap transactions. If you're going to do this, get his card, talk with folks and find out how this is supposed to be done, because this is the important part. Use a loan servicing company. We've already talked about this a little bit. Investors usually don't use a loan servicing company. It's really just up to the buyer and seller. If it's in buyer, in seller, in buyer, you're going to want that loan servicing in place. So let's say that you found the property that's a distressed situation, mortgage is behind 2 months, they owe $2,000, they can't, there's only about $10,000 equity in this thing, so you're gonna take over this property, but you go and find an end buyer, and that end buyer is gonna pay about 10 grand more, so you're gonna pay the mortgage up $2,000, give $1,000 over to the seller, they go away, you make about 7 grand on the deal. You're gonna use a loan servicing company in that situation. Do not ever leave an assignment transaction not using a loan servicing company. I think it costs $40 a month, and it'll.
Some as low as 18. Yeah. Got one that's good for 18 a month.
Is that right?
Yeah.
Good. Yeah. It's cheap. Yes, sir.
I've got, okay, so let's just say I'm a wholesaler, and I'm doing a deal where I go and I've got a distressed loan, and I put the deal together, put it on an assignment contract, I sign it over to an investor. They take the deal, they close it up, 6, 8, 9, 10 months later, they stop paying the mortgage, okay? The loan defaults, it goes into foreclosure, the original seller is pissed off, because I'm the one that came after them and got them to do the deal. Am I liable for this whole thing, or is that assignment I'm out?
So it's that's a true story that you just now. Those things occur, and so you're not liable, but get ready to pay for the ride. You're gonna get invited to the party, gold engraved invitation. Real estate agents might be invited too. Everyone's gonna be invited that was taking part. You'll ultimately win. What you do need to do when they get mad at you, you need to say, hold on a second, let's see what we can do. And if the buyer can't pay, buyer needs to have a little bit of honor and leave. So we'll draft, and I stay involved with all my mortgage wrap transactions for the life of the mortgage wrap, and I hate when we're doing 27-year mortgage wraps. And what I do is I educate the buyer as to what's going to happen. We're going to foreclose. You're going to be asked by an armed police officer to remove yourself and all of your items from the premises, and you're not going to know when that's going to occur. These are truths. And I say we can avoid this by signing a deed in lieu, and you can stay in the property for 60 days. You need to pay some rent while you're in that property for the 60 days, if you can. And if you can't, really don't care. I just want the deed in lieu, and now I don't have to do the foreclosure process.
Right, I'm kind of like, so if I'm saying to the investor, Bob over there, say Bob owner finances it out to somebody else. And then Bob doesn't use a loan servicing company because he's, I don't know, whatever, got a gambling problem. So all his money's going on red. Okay, and so as an investor, he's not paying, he's already under financing. So not only are the people that are living in it getting screwed, but also the people that we initially, the original sellers, are getting screwed too. And I'm the one that trusted Bob the gambler in the first place, so he's now making me look like I'm the one, because I went after the deal in the first place. I went knocking on the door. Well,
So the way to ultimately protect seller in that situation is try to, increase dollars over to them for the purchase, so the buyer has some skin in the game. If enough time is gone, the buyer has more skin because they're making payments, and they don't want to lose the property. But you have to work with them. You have to nuzzle them out. Get that deed in lieu of foreclosure signed, and hopefully the seller has received some principal payments, have some money in their pocket. If it's a conventional mortgage wrap, they may have gotten $30,000 down or something of that nature. So, you might be in a situation where don't throw me in the briar patch, now I got to go sell my property again and get $30,000, great. And I had one exactly like that. And it was funny, my client kept bitching at me over having to sell his property again and make another $30,000, $40,000 down payment. I was like, you don't understand what's going on here, this is good. But I think he just liked to razz me. But that's the way you protect from that is make it a benefit for the seller.
As wholesalers, just middlemen, like, I go to these events, there's 6, 7, 8 guys, girls, whatever, that want my property. I do something. And so I drop it off to Bob, who I don't even know. He just fits the criteria, he goes close on it. I never see Bob again. A year and a half later, all of a sudden, somebody's blowing up my phone.
Yeah.
Some bitch. The guy that we ended up doing the deal with is screwed. I'm like, I don't know where that guy is.
Removing yourself is going to increase risk. If that person that you're assigning that over to is not smart. No, that's a problem. Yes, go ahead, sorry.
Vernon Reed. Vernon Reed. They have Lillian Wang. Lillian Wang.
So, real quick, there's a 5016 notice, and you take this mortgage wrap transaction over to a conventional title company. They're not going to know about this disclosure, but this disclosure is required if a property is encumbered by a lien. And what it does is it provides all the specs about the loan, interest rate, maturity date, monthly payment, lender information, contact information. It's not needed if you purchase title insurance, and provide the notice anyway. This will be one of the documents that I send you if you shoot me an email. It's a real good document to get filled out at the very, very beginning because it lays out everything. Here's what the payoff is on the loan. Here's taxes, how much the taxes are per year. So it's a good document to get filled out very, very early. Similarly, the closing documents, you're going to need a deed of trust, promissory note, warranty deed, a vendor's lien in that warranty deed, disclosures. If you have a subject to, and remember what a subject to is, I'm just taking this property over, you don't need a full set of documents. However, I say use a full set, and here's kind of the key point. You don't want to look as if you're taking advantage of a unsavvy seller, buyer, etc. That should be the overriding goal in doing any of these transactions is complete transparency and disclosure. No one's hiding the ball. We know there's a due on sale clause. We know that there's a mortgage wrap. We know there's an underlying lien. The more transparency you have, the less problems you're going to have in the future. So we're going to use a full set of closing docs. Costs. There's an attorney out of Waco that will slap some documents together and send them to you for $150, and you go and close your own transaction. You draft up your settlement statement. You get everything notarized. Do your own recording and just knock it out. If you use this, get my business card. I'll represent you in the litigation that is going to occur. I've done it 3 times so far. You can go to a title company, as we were talking about. They have attorneys in-house. They also have doc prep attorneys. They charge $300 to $750, and they're going to give you some really, really good documents in regard to the deed of trust, the deed, and the promissory note. The seller will have redemption rights, and they'll be protected, and then you won't have the disclosures that are required. Your escrow account won't be trued up at the closing. Taxes may or may not be taken care of the right way. Insurance won't be in place the correct way because they don't understand what the heck's going on there either. And about 3 out of 10 times you'll be fine. In terms of ticking time bombs, you only have 7 out of 10 ticking time bombs. And that's why I say use a fee title office, an attorney-owned title office. One where the attorney is active. There was some commercial out there, if you don't use my company, use some company. If you don't use my attorney title office, use an attorney title office. There's I'd say about 4 or 5 of us that know what the heck we're doing here in Austin. There's probably about 40 or 50 or 60 that do this stuff. Some are very proud of their product. Y'all heard of Wally Wrap? I love that guy. He trademarked the term Wally Wrap. That's beautiful. I have phone calls. People call me, hey, do you do a Wally Wrap? I mean, sort of. No, Allen Wrap. Never mind. What do you want? I mean, he's great. So he'll charge you, I think, $2,500 per side, $3,000 per side. And he gets business. God bless him. That's great. I say good for him. My fees are $750 per side, And I think we probably have the best product in Austin, Texas. We close all around the state. I don't know the other attorneys in Dallas, San Antonio, and Houston as well, but here we have a good product and a good team. And I think, the natural end of a mortgage wrap. A mortgage wrap does want to end. So if you have a mortgage wrap, and what I'm saying, end user mortgage wrap, so conventional seller to an end user buyer, you want that to be short term. I think I usually say about 2 to 5 years. You got to look at the offending item that's preventing them from qualifying for a conventional mortgage. If it's bankruptcy and they're only able to get FHA, well, you're 4 years out. If it's credit issues, 1 year is way too short to fix credit issues. You need to look, 2, 3 years. The mortgage wrap on a conventional end user situation wants to end and end quickly. I had one fellow sold, I think it was about a 3-year mortgage wrap, called me and said, "Hey, we want to go ahead and extend this for the entire maturity period of the loan, the 25 years." I said, "You don't want to do that." He said, "Yeah, we do." I said, "Well, I'm not going to do that." And so sure enough, they went out there and they got it. And then about 3 years down the road, I get a phone call. "Hey, this lady needs to refinance this thing, man. She's still carrying my mortgage." "Yeah, that's why I told you don't do that." And that mortgage ended up getting foreclosed on because of all the problems. Now, this is different if you're an investor. As an investor, you're coming in, you're going to take that property subject to for the remainder of the mortgage, the maturity date. So you're going to have yourself a 27-year mortgage. And I think, there, yes?
Dodd-Frank require you to carry it at least 5 years?
So I don't want to get too deep into Dodd-Frank.
No, I just have one question, that's all.
So what I'm seeing is folks are ignoring Dodd and Frank, both of them. They're not attempting to comply. What they're doing is they're getting the RMLO, and what I consider that to be is risk shifting. So if someone comes back and says, "Well, you gave me this loan and you shouldn't have because I didn't have the ability to repay," well, talk to the RMLO on that. That's not my issue. So they're doing the RMLO, but they're not complying with some of the other items on the Dodd-Frank issue. And I don't think it's necessarily that dangerous, because not complying with that portion of it is no different than not complying with the other parts that you can't comply with, even the ability to repay.
Basically, it says 5 years, but you can just do it.
That's what I see them doing.
Okay.
Now, I have a disclosure that I have for people to sign off on if they want to, and it's not tested whether that disclosure and waiver would work or not. But the key is the people who are ignoring it, what they're doing is they're making a business decision to say, if we do have a default situation, we're not going to go and immediately start hammering them foreclosure. We're going to try to work with them. Because what Dodd-Frank says is you have 120 days before you can pursue foreclosure in a default situation versus 0 days in a conventional or prior to Dodd-Frank. So you have to wait 120 days. During that 120 days, you have to do loan modification efforts. Doesn't tell you what those efforts are, but please do those. And then after that, you can begin the foreclosure process, the 20-day notice and the 21-day notice. So now we're 6, 7, we're about 8 months into this, hey, you should be paying thing. You just have to work with them and get them out. Or modify that loan if possible. But if they can't afford the loan, I doubt modification is going to help them. They're in a different situation. So what actually today, we have a default situation. I told the seller, I said, you want to work with them, you want to get a deed in lieu, give them 60 days. They're going to try to sell the property or what have you. Try to get payments. If you don't get payments, just write it off as a business expense and get that deed in lieu. And so they came in and signed the deed in lieu today, and that ends our problem. So you just have to work with them. And that's what I see the investors doing, is they're saying, I'm just going to work with these folks. Because compliance, resistance is futile?
Yeah.
Compliance is futile.
I mean, when I seller, I tell them, you need to be prepared to carry this for 5 years.
Yeah. I mean, if you want to comply with a portion of the statute, you can. I just don't think you can comply with it 100%. Yeah. Okay, so that's that. Yes, sir.
What if the seller wants to get a new loan by us? I think that's the biggest objection.
That's a good question. So what you have is you have a debt-to-income issue. You're carrying that $200,000 debt, and now you're trying to go out and get another $200,000 debt, and you can't because that mortgage is still on your credit reporting. What the lenders will do, and the time period is different, but once you have a certain seasoning, sometimes as short as 30 days, sometimes 6 months, of showing good payments of that mortgage wrap, they treat it kind of like a lease. You show good payments of a lease for 6 months, well, they subtract that off of your debt portion of your debt-to-income ratio. So I've seen people be able to qualify, and pretty quickly too, surprisingly. Yes, sir.
Did I understand correctly that if I've got a house and I bought it on sub-2, and I want to sell it to an investor, and they're doing a wrap, do I not have to be compliant on the proof of the ability to pay at that point if they're not used as a closed-end?
Correct. Yeah, you are outside Dodd-Frank if it's a commercial property. And what we do is we hope that they're purchasing an entity, and we sign off on our business purpose affidavit, we sign off on our non-homestead affidavit, and we're good.
But the investor's going to buy it, and then turn it lease it. They're not going to have it as they're buying a residential, single-family residential, they're going to lease it.
Correct.
Okay.
That's commercial purpose. Absolutely. Yes.
How are taxes treated for the seller? Are they capital gains that they, for the income over and above if there's interest?
I can't tell you how much of a tax attorney I'm not. However, I have listened to that fellow that I associate with. So you got $250,000 exemption, single person, $500,000 exemption. They're selling their house via mortgage wrap. You're looking at the basis, and then you have debt on there. So if I have a $300,000 house and I owe $200,000 and I'm selling that, I've only got the $100,000. So I'm still below that threshold. If you're exceeding 250 as a single or 500 as a married, I'm not certain you're doing a mortgage wrap. We have wrapped a $1.5 million house once, but poor fellow was on tough times and couldn't qualify, but he had all the cash.
But would that only be for a homestead though, if it was an investor?
Okay, investor, then, wow, you're really going to press me, aren't you? On your investor, so if you have that less than 2 years, you're at short-term capital gains. More than 2 years, you're at long-term capital gains. Are you going to save me?
If an investor owns the property and they've owned it for over a year, and then they're just going to sell it on the wrap, they'll pay 15%, they'll pay the capital gains rate, and they've owned it for over a year. If their income is above, I don't know the exact number, but $150,000, they'll pay the additional 3.8% Obamacare healthcare tax act thing. In addition to that, but they'll only pay it on the proceeds that they get. So they're not going to pay it if they sold it on the wrap and they're not getting all their money right now. They're only going to pay the taxes on the proceeds that they receive at the time that they close under the wrap period in that year for the wrap.
So not the promissory note amount.
No. Yeah.
Right. Well, sometimes they do. The phantom income, government can do fun stuff for us. All right, any other questions? So it's all clear.
No, we got a question about taxpayer.
Yes.
I might have missed this, but how do you set a term for just a few years on the note that you're running around?
It has a balloon. It's a 30-year amortized loan with a balloon at X years.
Oh, you can put a balloon on it.
Yeah, well, yes, you can. That's what they're doing, and I see more balloons than not, and these people know about Dodd-Frank and et cetera. So shoot me an email. I will get you the slides. I don't think the slides are that helpful. I have an FAQ document that's very extensive, and we'll send you a little checklist for the TREC 1 to 4, and the 5016 notice. Thank y'all.